Good morning again. My name is Steve Buckley. I'm with the New Hampshire Municipal Association and Legal Services Council, and this is ZBA Applications Part 2, which is mainly focused on conflicts of interest and the right to know law and related subjects, so that you as a zoning board of adjustment have the appropriate level of impartiality and public notice and participation to make fair and reasonable decisions, which I'm sure you'll always will do in your activities as a member of a zoning board of adjustment. And so this presentation will conclude in about an hour. Again, I apologize. I'm not able to be with you live on Saturday the 7th, since I am unavoidably needing to go to some other activity on Saturday. And so OPD has graciously allowed me to pre-record this presentation for your viewing at the Spring 2022 Planning and Zoning Conference. What this part of the presentation is really designed to remind Zoning Board of Adjustment members is to understand the relationship you have to the public at large through this important element of governance of local government, is probably the best way to put it, and that is the right to know law, RSA Chapter 91-A. So the right to know law, as you may already know, is really the guiding requirement and mandate from the legislature, but most importantly from our New Hampshire Constitution, to ensure that at all times the local government is open, accessible, accountable, and responsive. So that's the language directly from Part 1, Article 8 of the New Hampshire Constitution. And that constitutional requirement was then embodied in the law that became known as the Right to Know Law, which was first adopted in 1967 and has since been amended and updated ever since then. And in particular, the first section of 91-A says the purpose of this chapter is to ensure the greatest public possible access to the actions, discussions, and records of public bodies, to ensure their accountability to the people. And so in many ways, how it is that the Zoning Board of Adjustment does its work is defined by these requirements of the right to know law. The starting point is to always understand how does the right to know law require a public body to operate. And the first starting point in understanding when the right to know law applies is whether or not you have engaged in a public meeting. And so therefore understanding what the definition of what a public meeting is important. And in particular, 91-A:2 says that a public meeting is an occasion when a quorum, and that would in your case of a zoning board of adjustment, when 3 members of a public body convenes so that they can communicate contemporaneously to discuss or act upon something over which that public body has supervision, control, jurisdiction, or advisory power. And I would just remind zoning board members, I mean, it's easy to understand that you're having a public meeting when you're addressing an application for relief, variance or special exception, or an appeal of administrative decision. But it would also be the case if you had a workshop to discuss granting variances or special exceptions for wetlands or uses in a wetland protected area. And you had a presentation from a soil scientist to help you understand better what are wetlands and how they're protected and what are their functions and values. That's still something over which you are clearly have supervision, control, of jurisdiction. You're not making decisions, but you're discussing it. And that discussion is something the public would have a right to know about and potentially attend. So just always remember, when there's a quorum of your ZBA, and that is the action of a public body, so that you're contemporaneously communicating that over something you have jurisdiction or authority, that's a public meeting. And a public body is defined, and that's pretty easy for a zoning board of adjustment. You are a public body defined by the zoning and planning statutes, chapter 673, chapter 674, define the main areas of what is a zoning board of adjustment, and then what are the duties of the zoning board of adjustment. And as a public body, you are subject to the requirements of the right to know law when you convene to discuss on matters within your jurisdiction, and you're able to communicate with each other contemporaneously. And contemporaneously could also mean if you're trying to carry out communications electronically, and you're all able to see a communication because it was sent to a quorum of the ZBA, and it was sent via the reply all method, which I would like to remove that button from all email programs to protect against inadvertent creations of public meetings by email string. That would also include advisory committees. So if the ZBA creates a subcommittee, it's not often the case the ZBA has subcommittees. I don't know many of you who are on a ZBA, but my experience is you have a ZBA meeting, you make a decision, and you move on. And that's all done usually at one meeting. I know that there are lots of ZBAs that have multiple meetings on difficult applications over a long period of time. My experience is we typically just have a meeting, someone's asking for a variance to put the pool in the front yard setback, crazy application before us, and it's heard one night and it's over with and we make a decision. And it's not often the case the ZBA would have advisory committees. I mean, I know occasionally, I suppose, you might have a ZBA, maybe have a member assigned to go to a planning board meeting when the planning board is discussing zoning amendments. But I don't think it's typical that a ZBA would have an advisory committee. But if you did, and it was created, let's say the chair assigns 2 members of the zoning board of adjustment to create a zoning input subcommittee. So your job is to come up with a list of things that the ZBA struggled with in the zoning ordinance and go to the planning board at a meeting and present suggested changes. So if that subcommittee had a meeting, the zoning input subcommittee, that would be a public body that would require compliance with the right to know law. The convening part of the statute is always important to keep in mind, and the convening means typically you're meeting in person. It can also can occur through discussions via email or text chains. So if a quorum of the ZBA was texting each other and carrying on a discussion on matters concerning a pending application, that would be a convening, probably not a proper one, but it would be a convening because it wasn't something that the public can attend. So emails and texts, by the way, could also be considered governmental records. And communications outside of a meeting cannot be used to circumvent the spirit and intent of 91A. Because all discussions of a public body should take place at public meetings. And I just want to read, I think, an important provision of RSA 91-A:2-A, and it's subparagraph 2, and it says, communications outside of a meeting, including but not limited to sequential communications amongst members of a public body, shall not be used to circumvent the spirit and purpose of this chapter. So if you have 5 members on a zoning board of adjustment, which you normally always do have, if member A picks up the phone and calls member B and says, I think we should vote like this on this application that we continue to the next week. And then you say, why don't you, member B, call member C and tell member C the same thing. And then member C gets that call and then is told to call member D, and then member D calls member E, and pretty soon you have a sequential communication that really should have taken place at a public meeting. And so keep that in mind, that is also considered circumstances which are inconsistent with the duty to carry out discussions of public matters at public meetings. Pardon me for a second as I close a few windows here. Discussing board business. Chance encounters of social gatherings don't count. So if you run into a fellow ZBA member at the local 5 and Dime, we don't have those anymore, I guess, maybe at the local transfer station or at town hall, that's a chance or social encounter. That kind of social encounter would only be, circumstance with a you're not having a discussion on matters over which the public body has some sort of control over. So even any discussions that you might have, if it's discussing board business, it could be something that you have advisory authority over. And there can be occasions when multiple members of one public body serving of a different public body could get complicated. Generally, it's not an issue. So let's go back to my example. The ZBA creates a zoning input subcommittee, and the zoning input subcommittee goes to a meeting of the planning board to tell the planning board, the results of their suggestions for improvement. So the two members from the zoning input subcommittee from the ZBA are at the planning board. That's not necessarily a meeting of the advisory committee, because they're there for the purpose of just reporting back to the planning board, not for the purpose of coming up with the suggestions. So there's a situation where I don't think it's necessary that the ZBA post the meeting of the advisory of the zoning input committee from the ZBA is also meeting with the planning board on a certain night, because that's just, it doesn't rise to the level of a separate public meeting. Although I suppose if you wanted to absolutely eliminate all doubt, for when the ZBA's zoning input committee met with the planning board, you could post it as a meeting of that ZBA input committee at the same date and time that the planning board is holding its public meeting on zoning amendments. So what are the requirements of a public meeting? Well, there's basically three. And by the way, this is the minimum right to know requirement. It is not the different level of notice that may be necessary under the zoning planning statutes. So the minimum necessary requirements to comply with the right to know law in terms of public notice is 24 hours notice before your meeting, posted in two public places, one of which can be your internet website. And when you count the number of days, you do not include or count Sundays or legal holidays. Your public meetings have to be open to the public, and you have to have meeting minutes. So you have to produce draft meeting minutes at a minimum of 5 days from the date of your public meeting. So those are the basic right to know requirements. And now I wanted to spend a little time on some of the ethical obligations to ensure that planning board or ZBA members avoid conflicts of interest and retain the necessary impartiality that you must have in making judgments about granting relief under the zoning ordinance or direct administrative appeals. So it to some degree, it starts off with ethics, or what do we mean by what is ethical conduct? Sometimes people would say, well, what exactly is ethical conduct? How do we pin down that definition? Well, it really is perhaps best defined by the things it is intended to encourage. Ethics are designed to encourage avoiding conflicts of interest, disclosing whether or not you have a financial interest that might have a bearing on the decision that's about to be made by the ZBA, obviously avoiding criminal behavior, following state and local law, respecting confidentiality if it applies in a particular circumstance. May not be common to a ZBA decision-making process, but you might be privy to special legal advice that's provided by town council, which you should respect the confidentiality of the attorney-client relationship between the town attorney and the ZBA, and retain that confidentiality and not disclose it. So you could have a duty to respect confidentiality, not abusing your authority, making someone think you could grant relief for their particular benefit, treating people fairly and equally. And we've received a number of inquiries recently where there's been some concern that ZBA members are being rude and inconsiderate to people who are appearing before the ZBA or fellow ZBA members. So it really is necessary, ethical, to treat people fairly and equally. Employing honesty, integrity, and trustworthiness clearly would all be part of acting with ethical behavior, and avoiding, probably more important than anything else, avoiding the appearance of impropriety. There are few statutory rules that directly address what are the expected standards of ethical conduct of a zoning board of adjustment member. Incompatibility statutes contain some clear rules but they're not really as particularly applicable to the Zoning Board of Adjustment. Case law does provide a number of examples that are not found in statute, but even these aren't complete. But I suppose more importantly, in terms of trying to decide, would my conduct be appropriate in a particular circumstance? Keep in mind the ethical golden rule. If you were to read about some scenario occurring somewhere else in a newspaper, how would you feel about everyone who participated in that decision-making process? If you feel that, that kind of information or the disclosure of conduct in a particular set of circumstances would be a little icky and make you feel uncomfortable, then the answer is no. It's probably the case. You shouldn't do perhaps what is considered or might be under consideration. You should avoid it and avoid behavior that might, you'd wince when you saw it, especially if it was in a newspaper above the fold. There is a very specific statute that governs the behavior of land use boards and zoning boards of adjustment. I've highlighted the key provision here. It's found in RSA 673:14. A member of the Zoning Board of Adjustment cannot participate or sit on the hearing of a question in a judicial capacity, and that's what a ZBA member is. You act in what we say is a quasi-judicial capacity. You hear evidence and you weigh the evidence. You hear from people from both sides of decision-making dispute, and you apply legal tests to those pieces of evidence, and you make conclusions. And that's very similar, if not exactly similar, to what a Superior Court judge or a judge in the district court would do. So you have the obligation, as indicated here in 673:14, to make sure you do not have a direct personal or pecuniary interest in the outcome, which differs from the interests of any other citizens. So two really easy to understand direct personal or pecuniary interest. If I'm a butter to a subject property, I have a direct personal interest in trying to defend my property from what I would say is adverse consequences of a proposed variance. So I automatically must recuse myself. If my employer is the applicant for the variance, clearly I have a direct personal interest, pecuniary probably, in trying to retain my job if for some reason what my employer does or does not get could impact my employment. So I would have a duty to avoid that conflict of interest, because that would be a pecuniary interest. And a personal interest could also be the person who's made the application is someone who I am related to by blood or marriage, or a close personal friend. Or another example, which is really a little bit different context, the person who is, let's say the person has a lawyer representing them in front of the Zoning Board of Adjustment, and that lawyer also happens to be my personal lawyer who I rely upon a great deal. That's the kind of personal or pecuniary interest that may direct a necessary decision on your part to recuse yourself from that particular application. But you also have a duty, as the rest of this part of the statute says, to understand that if you would be disqualified from hearing this case in the same manner as a member of a proposed jury who would hear the same case in the Superior Court, you would also have an obligation to avoid participating in that particular decision-making process. So what are those juror disqualification standards? They're found in a separate statute that would be of aid to you in making a decision. Maybe I don't have a personal pecuniary interest, but one of these other juror disqualification standards might be something that would require me to recuse myself. Do you expect to gain or lose upon the disposition of that ZBA application? Are you related to either party in the case? Have you advised or assisted either party? Have you given advice to the applicant supporting or opposing his particular application or her application? Have you directly or indirectly given your opinion, or have you formed an opinion before you hear the evidence? Have you prejudged? Are you employed by or employ any party in the case? Are you prejudiced in any degree regarding the case? And do you employ any of the attorneys appearing in the case pending before the Zoning Board of Adjustment? If the answer to any of those questions suggests that you have something which suggests that you're not indifferent, you should probably seriously consider recusing yourself from that particular application. We do differentiate between decision-making procedures which are legislative versus quasi-judicial. So let me just state what would be a possible legislative decision that could have a bearing on whether a member of the Zoning Board of Adjustment should recuse yourself from a matter versus one where you are making a quasi-judicial decision and you have a different level or standard of deciding whether you have to recuse yourself. So a legislative decision is something which is widely felt. It's a policy judgment, and you must act in the public's interest, but you don't need to be indifferent. So as a member of the Zoning Board of Adjustment, if I, again, going back to my example, if I was a member of this subcommittee from the ZBA that was designed to give ZBA input to the Planning Board on zoning amendments, let's assume for a moment that we had suggested certain zoning changes that would, we think, clarify the intent of the master plan or better reflect, how the zoning ordinance is supposed to operate. Just because in a legislative capacity we're suggesting to the planning board that there's a zoning amendment doesn't mean if that amendment got adopted, I would be precluded from acting to either consider whether to grant or deny a variance from that particular provision. Because when I was acting in front of the planning board proposing zoning changes, that was in a legislative capacity. I wasn't acting in a quasi-judicial capacity. And I'm not required to be indifferent there. And that would not preclude me from making judgments about the merits of the particular zoning amendment, assuming it got adopted when it came up as a question that I had to address as the Zoning Board of Adjustment. That's acting in a legislative capacity. On the other hand, when I'm acting in a quasi-judicial capacity, clearly then I have to have a higher level of avoidance of prejudgment because it's going to affect the rights of specific petitioner. I have to give notice and opportunity to be heard to the parties. I have to weigh evidence, and I must be indifferent. And so that's a different set of circumstances. So in acting on a quasi-judicial capacity, there's a much higher level of need to avoid an appearance of impropriety and to ensure impartiality. One of the things that our Supreme Court has made clear on what is the effect of an official who participates anyway. So it's a little hard to give you an example of how this would work for a Zoning Board of Adjustment member. But I suppose, again, going back to my example, let's assume, again, that the zoning board had created this subcommittee to make suggested zoning changes to the planning board. And then as a member of the planning board, a member of the let's say the zoning subcommittee came to the ZBA and said, we've looked at the issues and we think we ought to propose the following zoning amendments or suggest them to the planning board. And the whole board then votes to suggest, yes, why don't we go ahead and do that? So when I did that legislative decision, let's just imagine for a moment I had some, personal interest in the outcome in making that legislative decision. I was trying to support this proposal because that would perhaps assist a business that I thought had an important way in which you could improve economic development in my community. And maybe I have an interest in that business. So my participation in that legislative judgment, are we going to propose these zoning amendments to the planning board? My participation may not have been a wise thing for me to do, but my participation would not, even though I participated in the vote, would not take away from the ability of that decision to go forward to the planning board. It's a legislative decision. It's not, my participation does not infect the outcome. On the other hand, in a quasi-judicial decision, so now the zoning amendment that I wanted for this business is before the It's maybe, let's say it's a special exception. Now it's before the Zoning Board of Adjustment, and now this this ZBA, this new change to the zoning ordinance, which I had the influence on getting it before the town meeting. Of course, it's the town meeting that voted to adopt that zoning amendment, but now it's before the Zoning Board of Adjustment as to whether to grant a special exception that would benefit this business. If I participate in that decision, my mere participation would infect the entire outcome, and the entire case would be thrown out, even if my vote in favor was overridden by the rest of the board and they didn't vote in favor. My mere participation would undermine the entire decision, and the decision would be thrown out. So the courts would resolve this conflict of interest by examining the type of action taken and the facts. Was it legislative? Well, my vote in participating wouldn't be deemed to infect the outcome. But if it was quasi-judicial, if my vote took place, it's deemed to infect the outcome, and the entire decision would be thrown out. So what is the remedial action you can take to avoid that consequence as a member of the ZBA to have a decision rendered void because of my mere participation? So first of all, you can recuse. So you remove yourself, recuse. Hopefully the zoning board has alternates who can be appointed by the chair to carry on with the decision-making process when I recuse myself. Abstaining is really not the appropriate way to deal with the situation, because abstaining is just refusing to vote. You're still there before the board. So recusing is the remedy to avoid a conflict of interest, not abstaining. Another way in which we give tools to a zoning board of adjustment to deal with potential conflicts of interest is to allow the ZBA member or any member of the ZBA to seek an advisory vote. So RSA 673.14 Roman 2 allows a member of the ZBA to say, yeah, I'm being asked to vote on this special exception, which I influenced to the planning board to propose to the town meeting. It was adopted by the town meeting, and now it's being proposed by the business that I have kind of an interest in, but not that strong. Let's see what my fellow members think. Do you think I should recuse myself or not? And so the fellow board members can hear my description of what's the potential conflict of interest, and they can give me an advisory vote. By the way, the advisory vote merely gives me information from my fellow board members should I recuse myself. It's not binding. And by the way, no member of the public or an applicant can ask for an advisory vote. Should Buckley recuse himself? That's not appropriate. Only a member of the ZBA or the effective member can ask for an advisory vote. The other thing I think is really important to keep in mind, and I'll touch on this in some of the case law that will come up here shortly, is really to avoid expressing your opinion on applications on social media. As much as possible, any cases that are pending before your zoning board of adjustment, just avoid social media contacts, whether your town has a social media web page or Facebook page or Instagram page, whatever it is, really as much as possible, stay off those social media accounts, especially where you might be inclined to post comments or points of view with regards to issues of this type, such as pending land use matters that might come to the zoning board of adjustment. Generally speaking, it's more appropriate to avoid conflicts of interest and disclose your potential conflicts and remove yourself from consideration, even if it's a slight suggestion that you have a partiality particular outcome. It's better to err on the side of caution and to recuse in those circumstances where your partiality could be questioned. In certain instances, towns might have previously adopted local conflicts of interest ordinances. So these are adopted under RSA 31:39-A. I know that in my town, we do have a local conflict of interest ordinance. And one of the things that local conflict of interest ordinance requires is that I make financial disclosures of the nature of the things that I have a financial interest in. And that's kept on file at Town Hall. So people can make a judgment as to whether or not I have a financial interest that might impede my ability to be an impartial decision maker of the Zoning Board of Adjustment. It can also regulate conflicts of interest to some degree, both officers and town employees. It can enact more stringent incompatibility standards, and it can also suggest methods by which a member could be removed from office. There is a method for removing land use board members for malfeasance, bad behavior, misfeasance, not doing their job, or neglect of duty. But that's a separate removal process, which is carried out by the governing body. A local conflict of interest ordinance would really define some level of behavior, which is suggested by town meeting, an ordinance adopted by town meeting, which a member of the ZBA should avoid and should recuse himself. So it might be prudent just to inquire whether your particular town has a local conflict of interest ordinance that had been adopted under RSA 31:39-A. Couple of case studies, which I just want to go through with you because I think they are important in setting standards for judging what are circumstances that should be avoided or where a member's impartiality could be questioned. So the first of these is the Winslow versus Holderness case. Is probably the most well-known case in New Hampshire to deal with the necessity that people acting on a quasi-judicial capacity, in this case it was a planning board, need to avoid circumstances where they're deemed to have prejudged a case before they even hear the evidence. Well, this was a circumstance where there was an abutter appealed the planning board decision of the approval of a subdivision. And a person who was not a member of the planning board at the time, before becoming a member of the planning board, also a resident of the community, obviously, had spoken out in favor of an application for a proposed subdivision. And then after having spoken about this particular application, which apparently was well known in the community, this person was appointed to the planning board. And once appointed to the planning board, he voted in favor of the proposal. So he had expressed his support of a project beforehand, prejudged it, joins the planning board, and then votes in favor of the application. The Superior Court reversed the planning board decision, and the applicant appealed, and at the Supreme Court level. So even though it got appealed, it got approved. The Superior Court said, wait a minute, that planning board member had prejudged that he should not have participated. And the Supreme Court affirmed the lower court and said it was proper to disqualify the planning board member because there was evidence of prejudgment that the planning board member had entered the decision-making process in a fashion showing they were not indifferent. They had already formed their opinion, because ZBA members, planning board members, are supposed to make their decision based on the evidence that they gather in the hearing room and they receive as part of the public process before the Zoning Board of Adjustment. And the court, and this is a key part of the court's decision, the mere participation by the one member, even if you backed out his vote, it was still going to be adopted. But that member's participation, which you couldn't determine how much of an influence they had on the other members, was sufficient to mean this decision had to be thrown out. So the mere participation of a member who participated and was demonstrated to have prejudged a matter and who was not indifferent would render the entire decision void. And that, again, points out the distinction in that particular case of quasi-judicial versus administrative and legislative discussions. Robert Foley versus Trustee versus the town of Enfield is also an important case, because this was a situation where a member of the ZBA was gathering information during the public hearing process. Well, actually what happened was the board had held a public hearing, had denied a request, and there was a motion for rehearing pending. And before the board had a meeting to make a decision, I think there was a further public hearing to consider whether to grant or deny the motion for rehearing. A member of the ZBA, the chair, sought out information on the Plan Link listserv, asking questions about, whether a precedent was binding on a zoning board of adjustment. It was seeking guidance that was somewhat material to the decision the ZBA was about to make on whether to grant or deny that rehearing request. The rehearing request is eventually denied, really on other grounds, but the applicant learned of this interactive exchange between the chair of the ZBA on these issues. And there was a number of comments from members of the public who were participating in PlanLink on this issue about precedent and whether they were binding. And so as part of the appeal, the applicant said, the ZBA chair wasn't indifferent. The ZBA chair was carrying out a discussion which was beyond the scope of the public hearing process, and therefore that prejudiced the decision-making that was undertaken by the Enfield Zoning Board of Adjustment. The court didn't really reach the issue, but I guess the important thing about this case is keep in mind that the way in which you interact with social media when you're in a public decision-making process, you heard a case, you've continued it to another night, and you're going to have a later public hearing or a continued public meeting to make a decision. In between the first public hearing and the next public meeting, if you're engaging this in this gathering of information through social media, it could be argued that you're gathering information outside the hearing process, and it's prejudicial to either the applicant or those who are opposing the application because they don't know what you're gathering. They don't know to what degree it's going to impact your decision making. So it's just indicative of how I would again suggest social media can be both a tool, but it can create a lot of problems and putting in jeopardy the impartiality of a ZBA member. And that's why, in particular, the Z1 Express case is important on that subject. So this was a conditional use permit, a zoning type decision-making process, which was carried on by the Manchester Planning Board. So those of you familiar with the Innovative Land Use Control Statute, it allows the Planning Board to exercise some zoning authority by granting conditional use permits. This was a proposal for a gas station. They needed a conditional use permit to be built within a certain residential district. And after most of the public hearing had taken place, but before the meeting that was about to take place to make a decision, there had been, by a number of abutters who opposed the gas station, a website created. And at that website, people could exchange comments. Two planning board members who were sitting on the planning board considering the CBA then posted messages on the listserv saying, we support the residents, we oppose the application. So of course, when one of the ZBA members, the planning board members who had made this posting, comes to the next meeting, the applicant's attorney says, member so-and-so has already expressed his opinion on the subject. He is not indifferent, he's not impartial, and he should recuse himself and should not participate in the decision. And the member, who's also an alderman, said, nope, I'm going to go ahead and vote. They voted against the proposal. And on appeal to the Superior Court said that the member's failure to enter deliberation with an open mind, which was reflected by the fact they didn't have an open mind because they opposed the project by these internet postings, infected and undermined the public trust in the overall functioning of the planning board. So that's, again, a reason why I would just encourage ZBA members to stay off social media, don't be posting messages related to any applications pending before the Zoning Board of Adjustment, so that you can avoid someone arguing your decision was infected by partiality or prejudgment. So with that, I would just bring this presentation to a close. This is the ZBA Part 2. And remind you again, I apologize, I can't be there with you today. So you would be able to, if you wish, to send me follow-up questions to legalinquiries@nhmunicipal.org or by calling next week at 603-224-7447. And I would thank the Office of Planning and Development for inviting me to participate in this presentation to you today. And I hope you find it beneficial in carrying out your duties as a member of the Zoning Board of Adjustment. So thank you.